Hi, my name is Jessica Swartz. I am an attorney with the Education Practice Group here at Miller Johnson, and this is this month's 5-minute message on Title IX athletic regulations, notice of proposed rulemaking. So how did we get here? As many of you know, Department of Education has been hard at work promulgating Title IX regulation. When the Biden administration came in, they issued more proposed regulations, first in July of 2022, but at that time they said that those proposed regulations did not cover athletics and that they would be issuing new regulations that would address gender identity protections in athletics. In April of 2023, they issued those regulations. So what did they do? They revised the regulation 34 CFR 106-41B to add a B1 and a B2. We're going to break this regulation down into several different pieces. So the sex-related criteria, this is the first step saying that if schools are going to use sex-related criteria to divide participation on their sports teams, that is okay as long as there's a de minimis harm. And this is the same as what the current regulation is. So there's no change here. What the current regs have always said is that if there's schools can make some distinctions based on sex in athletics. The second part, though, and this is the new part, is looking at whether that sex-related criteria would at the same time limit or deny a student's participation on the team that is consistent with their gender identity. So what this means is that they would look at whether some of those sex-related criteria, such as using a sex marker on a birth certificate or requiring physical exams or tests of some sort to limit participation. The third is that schools must look at each level of sport, each sport individually, each grade in the education level of the athlete when evaluating whether the criteria they want to install meets these definitions. And Ed recognizes that this sounds like a lot of work to do for every single sport and level of competition, but it reiterates the only reason a school would need to do this is if for some reason they are limiting a person's participation on the sport that goes with their gender identity. So the next two pieces go together. If a school is going to put in these criteria that meet those first three levels, then the criteria must be substantially related to achieving an important educational objective. Substantially related, this is a legal term, comes from the case law, means direct, substantial relationship between the objective and the means for obtaining that objective. And the important educational objectives, Department of Education has explained, some of them are gaining widespread participation in sports, ensuring fairness in competition, and in limiting sports-related injuries. Department of Ed very clearly underlined their position that the general disapproval, so putting in these restrictions based on general disapproval of a student's chosen gender identity, is not an important educational objective. So if a school meets all of these and putting in their different regulations and limitations on gender identity, then they must also show that by putting these in, they have worked to minimize any harms that would come to those who can't participate because of their gender identity. Some of the harms that Department of Ed identified are forcing the disclosure of someone whose gender identity does not match their sex, forcing them to disclose that, or prohibiting those people from participating on a team that matches their gender identity. Department of Education also issued some directed questions in this notice of proposed rulemaking. First, they want to know if there are some alternative approaches that they could have taken to protecting gender identity in athletics. They want to know if there are any educational objectives for limiting eligibility based on gender identity. They want to know how the criteria could change depending on the sport, the level of competition, the grade. They want to know if it's possible that earlier grades could ever meet these standards, and if so, what would be that criteria? They explain in the preamble that in their opinion, it's very unlikely that an elementary school or a middle school team could meet these criteria, but there's a potential that high school and college levels could. They want to know what are some ways that schools could minimize harms if they're looking to impose these restrictions. They also want to know if there's anything else that they should include. So as you can see, that's a lot of information in the proposed rule. If you were interested in learning more, you can go to the preamble where they've linked a lot of case law and policies. They also provide a comprehensive history of Title IX statute and regulations in the preamble. So again, I'm Jessica Swartz, and if you have any questions about this or anything else, please feel free to reach out to me or other colleagues in the education practice group, and we'd be happy to help you.